Hey there, this is Professor Nathenson. This is number 8 in our series of discovery videos. This one's on production of documents and things under Rule 34. So we're going to talk about Rule 34. We're also going to talk about electronic discovery under Rule 34 and some of the other aspects of Rule 26 that bear on electronic discovery. Let's start with the questions. Let's start with Rule 34. Which of these can be discovered or requested under Rule 34? Paper, rock, painting, hard drive, a visit to a place of business. The answer is, of course, all. Rule 34 says that a party can serve on any other party a request within the scope of discovery under Rule 26b, a request to produce and permit inspection, copying, testing, or sampling documents, electronic information, ESI, electronically stored information. So we're going to call that ESI. Including, that's non-exclusive, right? So this list doesn't include just what's there, but it can include other things. Writings, drawings, graphs, charts, photos, sound, recordings, images, and other data or data compilations, right? They can be stored in any medium from which information can be obtained directly or after translation into a reasonably usable form. So that's not just paper, okay? It's also a document that can be printed onto paper or viewed on a screen or heard through a headphone. Anything that's can be information that's either viewable or indirectly translatable into some sort of perceptible form, right? But it's not just documents, whether it's physical or in electronic form. It's also things. In addition, it's the ability to go on and visit land. I mean, land or other property. So that could be a house, a business, a lot, a mine, what have you. Okay? So even though people often say Rule 34 is about document requests, it's actually about so many other things. Can a party use Rule 34 to request things not in the possession, custody, or control of the other party? The answer, of course, is no. So, for example, if you want a copy of, I don't know, you want a copy of, Professor X's Social Security card. Okay, well, you can't ask Professor Y, all right? Not unless that Social Security card of Professor X is in possession, custody, or control of the person you're giving the production request to. So you're thinking, well, oh, that doesn't matter. You should just ask Professor X. All right. Fair enough. Let me rephrase then. You can ask somebody for production of something that's in their possession, right? So, for example, the blue pen that I'm using right now on the screen, you could make a production request for that if it falls within the scope of Rule 26b, relevance, non-privileged proportionality, right? But what if something's not in my possession? I gave it to my wife. I give it to Mrs. Nathenson. I say, Mrs. Nathenson, please hold on to this. I'm worried that somebody's going to want to inspect my blue pen. They're going to make a discovery request. So I give it to you so that when they ask me for it, I say, sorry, I don't have it. Well, it doesn't matter because it's in my control. All I have to do is ask Mrs. Nathenson. She'll give it back to me. Same thing as if I give the pen to my lawyer. All right? Not in my possession. It's in my control. Okay. What if I have something, okay? So what if Mrs. Nathenson gives me her pen, okay? And then somebody wants to see Mrs. Nathenson's pen and they request it from me. Well, that's in my possession or it's in my custody, right? So if I have it, possession, or it's in my custody, or even if I don't have it in my possession, I can get it back. Then that's stuff that can be fairly requested in a Rule 34 production request. All right, next question. Can you request documents by name? Must you? The quick answer is yes. Must you? No. In fact, why would you? So here we look at 34B. All right. The request may specify the form or forms in which, oops, bad one, sorry. This one here. The request must describe with reasonable particularity each item or the category of items to be inspected. So I could identify by name the document or thing I want, right? But you want to be careful here. What if I think that the document I'm looking for is the, we'll just call it the X21 document, all right? And there is no such thing as an X21. What I should have requested was the X21B document, right? Well, if I request this and the recipient of the production request doesn't have that, they have this, they might just not give me the X21B document because I haven't requested it. I requested the X21. So yeah, you can request by name, but typically, why would you do that? What you could do instead is request by category. So, say the X21 and the X21B documents are documents regarding spills of fuels onto the plaintiff's property, right? So, even if I get the name of the document wrong, as long as this category includes this document, then they should be giving me this document right here, the X21B document. In fact, if there's other documents that also fall into this category here, they should be giving me those documents as well. So I won't tell you not to request things by name or by item. That's perfectly fine. But be careful, because if you get the name wrong, you may end up with nothing. So, in the alternative, or in addition, you might want to consider requesting things by category. Let's see, next question. I'm hoping you think the answer to question 4 is no, no, no. May the responding party throw all the documents in a big box, shake the box, and produce the documents in that matter. In other words, can you play 21 pickup, right? You take a nice organized box of documents, and then you're just going to throw them on the floor, see where they land, and that's how you're going to produce them. No, you can't do that. 34B2. All right. Unless stipulated or ordered by the court, a party must produce the documents as they are kept in the usual course of business, or must organize them and label them to correspond to the categories in the request. Okay? So, first thing to take from that is they have to be organized, right? Either as they are in the usual course of business or pursuant to the categories in the request, right? So this would be how the responding party keeps them, and to organize them by the categories in the request would be how the requesting party has asked for them. Okay, well, the responding party has to choose one of those two methods to organize them, right? Now, a follow-up question would be, well, how about this? I'm the responding party, and I want to make things as hard as possible for the requesting party. So I know that I'm likely to get sued, so I'm going to intentionally keep everything really disorganized. Well, really in a way that is organized for me, but is super disorganized for them, right? It's like a secret code. Okay? And I'm going to organize them in a way that nobody can figure out how they all go together. Well, as insane as that sounds, there actually has been at least one case, probably more, where a company that was being sued fairly often decided to keep its documents in a disorganized way so that it would produce them that way when there was a production request. So the usual course of business organization meant, well, by usual course of business, disorganized. The court said, no, you can't do that. So I don't know whether that's, the majority rule or general rule, but that seems to be the right rule, how the law ought to be. In my mind, you shouldn't be able to organize things for your own business in a way that's going to frustrate other people trying to make sense of them in litigation. All right. So those are some basics on discovery. Let me know. Let me know just one other thing briefly. First, the rule talks about parties serving on other parties' production requests, but keep in mind that under Rule 45, okay, you can serve a subpoena on a non-party to either have them come and testify, all right, or to produce documents. So you can actually get documents from a non-party under Rule 45. A second thing to note is you may recall that depositions had a max number of 10 is the default max number for depositions, right? And that's measured by 10 by the plaintiffs as a group, 10 by the defendants as a group, and 10 by the third-party defendants as a group. Interrogatories are measured up to 25, including discrete subparts, for each party, okay, versus any other party. All right. Now, what about document requests? Is there a maximum? And the answer is no. There's no maximum. You can ask for as much as you want. Now, if you ask for so much that it becomes burdensome, then the other party very well may object based on duplicative requests or burdensome or not proportionate to the needs of litigation. And you'll recall that Rule 26b1 has the proportionality requirement, which may be used to limit discovery. And in a few moments, we'll note Rule 26, I believe it's B2C right down there. Another kind of proportionality type limitation, that if discovery is unreasonably cumulative or duplicative, or can be obtained from a more convenient, less burdensome, or expensive place, or so on and so forth, that can also limit discovery. So even though Rule 34 doesn't have a technical limitation, there are other limitations built into the rules that allow reduction or prevention of burdensome or duplicative or that kind of discovery. All right. Let's move on to electronic discovery for a moment. Now, ESI, electronic discovery, let's talk for just a moment about what that is. Okay, now electronically stored information is stuff that's stored not on paper, but rather in electronic form. That could be in a computer, right? That could be in a smartphone. That could be in some other sort of device. It could be in a separate storage device like a hard drive, a USB drive or flash drive. Gosh, what else could it be? So many other things. It could be in, internet logs from a service provider or from your own computer. So electronically stored information is stuff that's stored digitally in some device. Now, electronically stored information can be both easier for discovery, and it can also be more difficult for discovery. It's easier in the sense that if you can have a digital file or a digital storage device, such as a hard drive, right? File or a hard drive or whatever, you can run all of that through some sort of search software and search for keywords, right? You can search for keywords, and you may be able to find something really quickly that might have taken days, weeks, or months to find through a more traditional hand and eye based techniques. In fact, today a lot of discovery is done by having software make the first stab to look through the stuff, right? So that's a whole lucrative field of business which is technology that's used to aid with discovery. However, ESI can also make things much more difficult. First, there's lots of information, right? Second, there's many places where that information can be found. And if you're not careful, you can inadvertently disclose stuff, right? For example, in a Word file, you have not just the text of the document and its formatting, but you also have metadata. Metadata might include who created the document, who last edited the document, when it was last edited, how many times it's been edited. It can include comments. So you've probably seen how you can insert comments into a document. If it's a shared document, then multiple people might have made comments on it. If you have track changes enabled in the document, then you might be able to see prior versions of the document or changes that have been made to the document. And all that stuff's metadata. Can be extremely useful, but it can also be very dangerous because there's so much more information in so many places in electronic files where information might exist. That means before you produce stuff like that, you got to look through it to make sure that there's not any sort of information that's damaging to you that you wouldn't have to reveal, such as privileged information, such as work product, right, and so on and so forth. Other examples, with an email, okay, there's not just the text of the email, there's the from, there's the to, there's the subject, there's the time sent, there's the time received, there's the IP address from which it was sent, the IP address that it was sent to. How about web pages, okay, for the internet, for websites and all of that? You would have, oh gosh, there's so much information. There would be not just what the site looks like, there's also the underlying code, which can include HTML, Flash, other things like that. You can have the IP addresses of people that visit the website. You could have cookies that are on the hard drive of a user's computer. You have the cache, which are temporary files that are kept along with a browser. You have browser history. You can just go on and on and on about all kinds of stuff that are potentially found in digital files, so that even it's easy to search, or can be easy to search, it's difficult in the sense that there's so much more information for you to look at before you reveal it. So you can't just hand over your client's hard drive and say go at it, because if you don't yourself look at what's on your client's hard drive before you hand it over, you may be handing over things that, for one thing, aren't even responsive to the discovery request, but may nevertheless be damaging to your client. Stuff you're not even required to give over. You give it over anyway and it hurts your client. That's not good. You hand over stuff and it turns out that it's privileged or work product. That's not good, right? There's other stuff that you hand over that turns out it's got your client's confidential business information and trade secrets on it. Well, you might have to turn that stuff over, but you probably should have labeled it pursuant to hopefully a protective order that you've negotiated with the other side, and so on. So it's really hard to deal with electronically stored information because there's so much and it's so easy to make a mistake. Okay, so let's jump back a little bit more into this. Oh, one last thing I'll note is, you know how I noted how it was easy to search, it can be easy to search electronic information. Well, think just last week when FBI Director Comey made a fuss about Hillary Clinton's might have some new emails on Anthony Weiner's computer, and there were 650,000 emails that had to be gone through. And the FBI was able to go through those in less than a week, and they ultimately concluded that the emails either weren't from or to Hillary Clinton, or if they were duplicative of emails the FBI already had, or they were otherwise irrelevant, such as personal emails. Well, gosh, how do you go through 650,000 emails in the week? You do it with search software. And actually, it wouldn't even take that long to go through those emails. Okay, so that's one of the powers of modern technology. All right, moving back over here. All right, let's get into some of the details here. Now, first, we're going to talk about the rules, but I need to point out that much of the rules regarding electronic discovery are actually covered under each district court's local area rules, like the local area rules of the U.S. District Court for the Southern District of Florida, right? Plus, there's going to be standing orders of the court, as well as maybe orders from the individual judges, okay? So much of the law regarding ESI is actually contained in local rules rather than the FRCP, and the FRCP really covers just the more general stuff. All right, so may a party who requests ESI request the form or forms they want it to be produced in, 34B1? The answer is, of course, yes. A request for discovery may, not must, may specify the form or forms in which ESI is to be produced. And that can be in a wide variety of forms, right? So think like a document. You might want a paper copy, right? You may want the a PDF of it. You might want the word processing file it was in, right? You may want the hard drive to see if any prior versions of the file can still be found, right? Like a deleted version or a version that's been updated or changed. And you can see that as you go from 1 to 4, there's going to be more and more information in number 4 and much less information in number 1, right? You go to number 2, there might be some metadata. Go to number 3, there's going to be a lot more metadata because Word keeps a lot of metadata. You go to number 4, you're going to get a whole bunch of old files, right, with a lot more metadata, and so on and so forth. Now, if you're the plaintiff and you're making the document request, you might want number 4, right? So you could ask for that. But, you know, if you're the responding party, say the defendant's the responding party, you're really not going to want to give up number 4 if you don't have to, right? So the parties might fight over this. So how do we deal with all of that? All right, so we'll think about that in a second. I'll get back to that. Suppose a party requests ESI but does not specify the form or forms in which they want information. What should the opposing party do? All right, it's covered under B2, a couple parts. All right. If a request does not specify the form for producing ESI, then the responding party must produce it in a form or forms in which it's ordinarily maintained or in a reasonably usable form or forms, right? So, you know, if the requesting party doesn't say that whether they want 1, 2, 3, or 4, then the responding party gets to pick, so long as that's how it's ordinarily kept or in some reasonably usable form, right? Well, what if, give me a second here. Here it is, D. Suppose the requesting party asks for number 4 and the responding party doesn't want to do that. Well, this is under Rule 34B2D. The responding party may state an objection to the requested form. So say the requesting asks for number 4 and the responding party thinks that's too burdensome. So they can state an objection and say if they object to the requested form, then that party must state the form or form that it intends to use, right? So requesting party wants number 4. Say the responding party says, well, I'm going to give you number 1, right? Well, then the parties can fight over it, right? In fact, these kind of things are issues that are ripe for discussion at the Rule 26F discovery conference, right? Have parties try to hash out and agree amongst themselves how they're going to handle requests for electronically stored information, right? And such, any stipulations they come to can be included in the proposed discovery plan for the court to hopefully sign off on. Okay, and you know, if the parties can agree and there's a fight, and then you know either the requesting party can later make a motion to compel, which will be saying to the court, make the other side give me the stuff, what I want, how I want it. Or the responding party could make a motion for a protective order, right, to limit or to prevent discovery. Okay, so more on that when we talk on Monday. Let's move on to the last questions, 3, 4, and 5. Suppose a party refuses to produce ESI on the basis of undue burden or cost. Can the requesting party move to compel discovery? The answer, as we'll see, is yes. Look at that in a minute. In a dispute over ESI, what showing must the objecting party make before the court? Okay, well, that's going to be undue burden or cost, so, that the information is unreasonably accessible. And what showing must the requesting party make before the court? Well, that's going to be good cause, and we'll talk about that in a minute. If ESI production is unduly burdensome or expensive, must the court deny such discovery? The answer is going to be no. The court can deny it, but it doesn't have to deny it. What the court could do is a number of things. So, you have the Zubalecki case on pages 836 to 837, right? Some of the information is active data, right? For accessible information, the usual rules of discovery will typically apply, right? And the responding party will pay the costs of producing data. And let's note that briefly. Normally, the cost of discovery is going to be borne not by the requesting party who's asked for it. It's going to be borne normally by the responding party. Okay? You think, well, that's unfair, but keep in mind each side is typically going to be requesting stuff of the other side. So normally it's going to be the responding party who's going to bear the cost. Okay? Well, that's still going to be the case with active, easy to reach data. But what about when the information is not easily accessible? It's inaccessible, such as backup tapes. Or how about stuff that's on tapes from, say, 20 years ago, and that format's now kind of archaic, and we have to use old technology or locate old machines, or we have to hire experts that know the old technology. Now it becomes difficult, right? It might be accessible, but not easily accessible, right? It's not reasonably accessible. In such a circumstance, the court has a variety of options. It might limit or prevent the discovery. It might allow the discovery and share or shift the costs, right? Something else the court can do in when the discovery is unreasonably accessible or reasonably inaccessible, right? The court can, if the court is thinking about allowing discovery, it can do a test run, and that's what happened in Zubalake, right? Zubalaki. The court, with those old backup tapes, decided to do a small sampling of backup tapes, a small selection from all the tapes, and have them restored, have them searched, and then see how much useful information came from it. The idea being, if there was lots and lots of useful information, maybe then you allow even more electronic discovery. And if it turns out there's very little benefit to looking at these old tapes, then maybe we're not going to allow lots of electronic discovery of these old backup tapes, right? Now, the court also considered a number of factors in weighing whether we could shift the costs. And by shift the cost, I mean not go by the normal rule where the responding party has to pay, right? Maybe we'll go to a rule where we're going to make the requesting party pay, right? Or maybe to a rule where we'll have them share in the costs somehow. So, under the case law, factors like these were used to determine how and when to cost shift and all of those. And Rule 26 was rewritten after that to kind of codify a lot of these ideas. So under Rule 26B to B, it codifies a lot of these ideas. A party, and here that means the responding party, all right, the party to give the production, it need not provide discovery of ESI from sources that party identifies as not reasonably accessible because of undue burden or cost, okay? Not reasonably accessible doesn't mean we can't get it. It just means undue burden and cost in getting it, right? We can get it, but oh my goodness, it's going to be so hard and so expensive, right? So then what that means is the responding party says, no, I don't have to provide that discovery. Well, that's not the end of it, right? Because if the responding party had the unilateral right to say, no, not going to do it, I draw the line here, no further, right? Well, then everybody would say no, and that would be the end of it. There'd be a lot of abuse. So if the responding party says no, well, then the party who's requesting, okay, the requesting party could say, oh, yeah? And what they can do is make a motion to compel discovery. And in that case, the party moving to compel discovery now has the burden of showing that the information, whoops, my bad. I moved down a little bit. Okay, here, let me go down here. This is what the requesting party does. Okay, I jumped ahead a step, my bad. All right, after the responding party says no, then, that might be the end of it. The parties might negotiate, the parties might stipulate, the requesting party might narrow its request, the responding party might give in and say, well, I'll negotiate with you. But sometimes the parties aren't going to be able to negotiate and resolve it, right? So you're going to have possibly two things then. There's going to be a motion to compel discovery. That's going to be by the requesting party. Or you're going to have a motion for a protective order. That's by the responding party, all right? Motion to compel is asking the court to tell the requesting party, give the stuff up. Protective order would be the responding party asking the court to tell the requesting party to back off, right? And to prevent or to limit discovery. So let's assume that the parties can't get along, they can't resolve it, and now you have that motion to compel discovery or for a protective order, right? Okay, well, then the responding party, still here on the responding party, must now show to the court that the information is not reasonably accessible because of undue burden or cost. So you think, well, what's the difference between the first and the second sentence? Well, the first sentence here is the responding party communicating to the requesting party and saying, no, I won't do it. The second sentence here now is the responding party having to make the same showing to the court in the context of a motion to compel by the requesting party or a protective order by the responding party. Okay? Well, let's assume that we have this motion to compel or a motion for a protective order, right? Now I'm explaining it more clearly, I hope. Now the burden is going to shift from the responding party to the requesting party. Assuming the responding party meets its burden of showing the information is not accessible reasonably because of the burden or cost, now the requesting party has to show good cause for the discovery, right? If the showing by the responding party of inaccessibility is made, the court can still order discovery from the responding party if the requesting party shows good cause. And also the court has to consider the limitations of 26b2c, which is immediately below here, which point out that discovery can be limited if that discovery is cumulative or duplicative, right? Or can be obtained somewhere more conveniently, less burdensomely, less expensively, right? Or the party seeking discoveries had opportunity enough to get that information by discovery in the action already, or the discovery is outside the scope permitted by 26b1. Now, what's really interesting here is this right here is 26b2c, I believe. B2c. All right, and then B2c incorporates 26b1. And you'll recall from your reading in the video on a scope of discovery that 26b1 includes relevance is required. The information should be non-privileged. And additionally, and most importantly here, the discovery sought should be proportional to the needs of the case, right? And what's odd about 26b2c is that it incorporates 26b1, yet the requirements of 26b1 seem awfully similar to the requirements of 26b2c. So, kind of go figure. I'll let you look at 26b1 and compare it to 26b2c on your own. You come to your own conclusion. Anyway, so that's it for now. This is one of the last videos. So hope you found it helpful. And this is Professor Nathenson on Discovery. Over and out. Have a good day.